Okay, let's dive into a landmark 2008 judgment from the Delhi High Court that asks a really fundamental question. When does a law that's designed to protect someone become a weapon? This case gets right into one of the most contentious issues in Indian law, this constant tug-of-war between protecting women and the potential for that same law to be misused in family disputes.
Legal terrorism. Wow, that's a shocking phrase, isn't it? But those aren't my words. That's actually how India's Supreme Court, in a totally separate case, described the misuse of the very law we're talking about today. I mean, that phrase alone tells you just how serious this problem had become in the eyes of the courts.
So what exactly is this law? It's Section 490A of the Indian Penal Code. It was passed way back in 1983, and its goal was noble, for sure. It was meant to fight dowry harassment and protect married women from cruelty, and that includes both mental and physical cruelty from their husbands or their in-laws.
And this brings us right to the heart of the paradox of this law. How did a shield, something created with the best intentions, start getting seen as a weapon? Let's unpack that.
This slide really lays out the core conflict perfectly. On one hand, you have the absolute vital need to protect women who are in genuinely abusive situations. But on the other hand, there was this growing feeling in the courts that the law was becoming a tool, a way to harass entire families and settle scores when a marriage turned sour.
So you might be asking, why is an accusation under this law so incredibly powerful? Well, it all comes down to these three legal features. Cognizable means the police can arrest someone based on a complaint, no warrant needed. Non-bailable means getting bail isn't automatic, it's not a right. And maybe most importantly, non-compoundable means that even if the couple wants to reconcile, they can't just withdraw the case. Once it's in the system, it really takes on a life of its own.
And all of this led to a really powerful observation from Justice Kailash Gambhir, the judge in the very case we're looking at. He said that once these really harsh criminal proceedings get started, any chance of the couple getting back together was often just gone. The legal process itself was actually destroying the family unit.
All right, so let's get into the specific case that really sparked all of this change. Because this wasn't just some abstract legal debate. This was about a real family in the middle of a crisis.
So, the case involved a man named Chander Bhan and his wife. They were the elderly parents of the husband. Their daughter-in-law had filed a complaint against them under Section 498A, and suddenly, they were facing the very real possibility of being arrested and put in jail over a family dispute. You can see how this put the Delhi High Court and Justice Gambhir in a really tough spot. How do you do both things at once? How do you protect the daughter-in-law if her claims are true, while also preventing the immediate arrest of her elderly in-laws, an act that would almost certainly torpedo any chance of saving the marriage? But here's where things get really interesting. Instead of just issuing a simple ruling on their bail, Justice Gambhir saw a much bigger opportunity, a chance to tackle the root of the entire problem, and he proposed a solution that was, well, pretty radical.
He was trying to do two big things at once. First, he wanted to find a balance. He needed a way for the system to tell the difference between genuine cases of cruelty and, as he put it, trivial fights and ego clashes. And second, he wanted to try and save the institution of marriage itself. Because let's be honest, the kids are so often the silent victims in all of this.
And his solution was incredibly thorough. This wasn't just a simple fix for one part of the problem. No, he created a whole new playbook, a new set of rules for literally everyone involved in these sensitive cases: social workers, the police, lawyers, and even the courts themselves.
So, what did this new playbook actually ask each group to do? Let's break it down, because this is where the judgment becomes truly revolutionary and changes the game.
The very first step was all about de-escalation. The judgment called for social workers and NGOs to set up conciliation desks right there in the police stations to try and mediate these disputes before a formal case was ever filed. It also gave lawyers a brand new job description. He said they shouldn't just be legal fighters adding wild allegations to fuel the fire. Instead, they should be social engineers, focused on finding a settlement.
Now, for the police, this was a huge change. The judgment basically took an existing police order and made it a mandatory requirement. No more automatic arrests. From now on, before the police could file a formal case, and especially before they could arrest any relatives, like parents-in-law, they needed to get approval from a senior officer, a deputy commissioner of police. This put a crucial check and balance right into the system.
And finally, the courts. The message to them was crystal clear. Your first job is to be a peacemaker, not just a referee in a legal brawl.
In every single one of these cases, the court's first responsibility was now to try everything possible to bring about reconciliation. Only if that completely failed should the legal fight continue.
So you see, this wasn't just some one-off decision in 2008. It had a massive, lasting impact. Its ripple effects have been shaping Indian family law for more than a decade since.
You can actually trace the legacy right on this timeline. A few years later, in 2014, the Supreme Court's famous Arnesh Kumar judgment, which banned automatic arrests in many types of cases, was built on these very same ideas. Then, in 2017, the Supreme Court actually cited the Chander Bhan case by name. And fast forward to 2023, the new National Mediation Act echoes the exact same core principle. Mediation should always be the first step.
What this one case did was create one single major paradigm shift in Indian family law.
It was this fundamental move, a shift away from a system focused purely on punishment to one that put reconciliation and mediation front and center. It was a recognition that, in family disputes, helping a family find peace is its own very powerful form of justice.
And so, this entire judgment leaves us with a question that's just as relevant today as it was back in 2008. When a family is in crisis, what does justice truly look like? Is the goal just to win a case in court, or is it to restore peace?